This is the 39th annual meeting of the Inner Circle of Advocates. The first one took place in June, San Francisco, 1972. First, I need to tell you my qualifications as a trial lawyer before I started the Inner Circle of Advocates. In 1979, I got the first million-plus jury verdict in Tucson, Arizona, in a personal injury case, and in 1972 in a case called Ride v. Dial in Tucson, Arizona, a jury gave me $3.5 million, which was the largest verdict in the history of the United States in a personal injury case. It went all the way through all the appeals and was collected in full, as was the verdict for $1,000,001 the year before. I think the most important case I tried was a first-degree murder case where my client, on the witness stand, admitted she shot and killed her husband. The jury was instructed there was no defense of self-defense, insanity, irresistible impulse, or diminished responsibility. They could convict of first-degree murder, second-degree murder, manslaughter, or not guilty. And the first-degree murder conviction automatically carried the death sentence. This was in 1962. Remember, no defense of insanity, and I got a not guilty verdict. So before I started the Inner Circle, I had the qualifications to start the organization. And after those first two verdicts, I got about 15 or 16 more seven-figure verdicts in pretty quick order. What was the difference between the Inner Circle as I started it and as it is 39 years or 38 plus years later? In the beginning, I wanted to make sure that at the meetings, at the round table, it was members only, no guests, no members of the family, even though they were lawyers. When we had speakers on the program, the speakers made their talk and left. They were not allowed to certainly attend the meetings, nor were they allowed to hang around the hotel to network and try to get future business. Little by little, that has eroded. The qualifications are the same, and the Inner Circle is a brain trust. That's all that I was trying to do. I wanted an organization of just the best brains in the practice who would answer questions for each other and who could be comfortable saying to each other, there's something I don't know, or there are many things that I don't know. And the interaction of questions and answers had to be absolutely confidential with the greatest security. Having guests now, having speakers who even attend the round table and attend the meetings, the security and the confidentiality is gone. Who knows what these people say when they get back home, and who knows what they say to their other clients who are defense clients, insurance clients. But that erosion has come about, and if I had my druthers, which one of the board members asked me about recently, I never would have incorporated it. It wasn't necessary. There would be no board of directors. There certainly would be no guests, and the speakers would be allowed in the meetings only when they spoke, because the purpose was just to exchange information. So the rest of it, my fault, has caused this slow erosion, but apparently that is what you want. When it comes to court, by the way, I do something very unusual. I have worn this jacket, not this particular one, there are over a dozen of these hanging in my closet in court every day. Also the black knit tie. I want to differentiate myself from other lawyers, and particularly from the defense lawyers who wear different suits or in Arizona sport coats. When I started to practice 52 years ago, we did not wear neckties. In fact, very often we didn't wear our jackets but wore short-sleeved shirts because there was no air conditioning in our courthouse. But every day, just like a policeman wears a uniform, the judge wears a robe, the doctor wears a uniform, little Dickie Grant, the country lawyer, wore the same jacket, same necktie every day. My father, when I started, had 3 pairs of custom shoes made for me in New York so that I would be comfortable. And that is the way I've conducted myself, and it's been pretty successful. Not always. Out of the first 15 cases that I tried as a prosecutor, I lost 14 straight jury trials. So it was a process of learning. But in court, say in a death case, I would often start by saying to the jury, we are here to do the bitter bookkeeping of death. It is against every law of nature for a parent to bury their child. A debt has been created which the corporate lawyer would like to buy on the cheap. And then I would say, ladies and gentlemen of the jury, may it please the court, etc. But instead of starting off like everybody else, start off with what I really wanted to talk about. The thing that worries me is I've grown older, and when you're 80, you realize that you're near the end of your lifespan, you're near your expiration date, and we all have an expiration date, like a container of milk or a box of cottage cheese, except I can't see mine, nor can anybody else see each other's expiration date. I worry about, as members come in, they say that this organization is like any other organization they belong to, whether it's called ATLA or ABOTA or whatever it is. We're different. No one but plaintiffs' lawyers belong to the inner circle. Our average age is 64.8 years. We're not younger. We've all tried at least 50 personal injury jury trials to a conclusion, and now it takes 3 7-figure verdicts to get into the organization. I will tell you that getting $1 million verdict in 1971 was a rarity. I don't think that there were 20 lawyers in the whole United States that had it. And getting $1 million verdict today is no longer a rarity. You are unique. There are a great many trial lawyers in the United States. There are a great many experienced trial lawyers in the United States. But there are few great trial lawyers. A great trial lawyer is not a one-trick pony, but is a lawyer who consistently, dozens of times, gets substantial verdicts. And there are members we have who've gotten $80 million verdicts. We've got a lawyer who happens to be the wife of the lawyer who got the 80, who's gotten $28 million plus verdicts. So you are unique. The great trial lawyer is a rarity. The great trial lawyer is a worthy. You are great trial lawyers. You are unique. And keep in mind the inner circle is unique. Every trial lawyer, every one of us, is always looking for an edge. Please, at the inner circle, leave your edge at the door. As we say in Tucson, Arizona, where I've lived for 60 years, spent my whole adult life and my whole career, when you enter the bar, leave your guns at the door. It's required. In Arizona, you're allowed to wear your guns as long as they're not hidden under your jacket or under your shirt. Leave your edge. There are no elections. You don't try to be elected to the board. You don't try to be elected as an officer. You don't try to get a member of your family to take your place when you take emeritus or when you die. Value what you get for literally pennies a year to exchange information with 100 of the best trial lawyers in the United States. And don't let it change to become like any other organization. All of us work on automatic pilot, and when we go to a meeting of the X organization or the Y organization or the Z organization, we feel, well, it's like going to a meeting of the inner circle. You want to get elected to something. You want to get something done. You know, I can understand everyone wants to get something done, but don't play me or the members of the board for the village idiot or for a fool. It's obvious. You can't trick us when you first want to invite the guest and then want to propose the guest for membership, etc. All we deal with are words. That's all we've got with the jury. And what we often forget, or at least some of us forget, that the jury on the day of deliberation is a different jury that was selected on day one. The night before, the daughter tells the juror, I'm pregnant. Or the son comes in and said, I've just crashed the car. Or the wife suddenly decides she wants a divorce. Things happen. They happen that morning on the way to court. They happen the night before. They happen during trial, and people change. They are not jurors. They are a jury. The jury grows a communal nose, one nose, with which it smells the strengths and the weaknesses of the case. You can't fool a jury. You can't fool a judge. If you're genuine, and I'm preaching, as they say to the choir, the jury will trust you. And they trust you by how you dress, how you conduct yourself, and by the words that you use. I never, ever make a joke in the courtroom. To me, the law is a learned profession. A lawsuit is the most serious thing in my professional life. And the goal is not only to get the verdict, but to collect the money. The purpose of the lawsuit is not to get publicity, but to collect the money for the client. No matter what the jury does, the judge or the appellate court can cause great damage. And judges talk to each other, whether they're on the appellate court, on the Supreme Court, or on the trial court. The only thing we have is our reputation, and we can't be known as people who are edgy, who've not read our cases, or more important than anything, who are not truthful. So, as I tell the students to whom I sponsor both an argument contest for 15 years and a writing contest at my law school, all we have are words, and what you must do is read newspapers, magazines, see plays, and get that stock of ammunition. The reason the old-time trial lawyers, and I am one of those old-time trial lawyers, and the 52 who are dead among us, the old-time trial lawyers had one advantage over most of you. We had no TV. We lived with radio. We were entertained by radio, and radio taught us words. We learned the coupling of words, the words bubble, reputation. When you think about it, that's all a reputation is a bubble, a soap bubble that can be destroyed just like that. But talking about a bubble reputation, that's a crisp sentence that wraps up a bale of thought. So I think it is most important to have those phrases, to use the phrases. I was taught in school that a lawyer must be bold. I was taught by my father that you can dream and there is no charge for alterations. You have your dream, but you can change your dream. It's important that we say things to a jury in a heartfelt manner. When that baby dies as a result of the negligence of a physician or something else, by saying and talking about an ad in the classified that says, "For sale, baby shoes, never used," that tells a story. You and I, we are wired to be great trial lawyers. You can't make great trial lawyers. We understand that the difference between the Ten Commandments and the rules of evidence is that we can change the rules of evidence. Does the station leave the train, or does the train leave the station? We talk to the jury about our client and say, he was more than a meal ticket. He did more than earn a living. We know the sentence, the unknown soldier and his wife. Think about that. When you say the unknown soldier and his wife, people will think. And the gesture being so important about looking at the defense lawyer and saying, if Joe Murphy, the man that got killed because of their carelessness, could come back to life, he'd walk up to that corporate lawyer and he would say, "Shame on you, Mr. Jones. Shame on you." So I say to all of you, the inner circle is my north, my south, my east, my west, my workday week, my Sunday best. Take care of each other and take care of my circle of advocates. I'm sorry that I'm not with you, but Marcia and I wish you and your families good health, and a long life. Thank you.